So chapter 6, estates and interests. So in this chapter, we're going to identify the characteristics of estates and land, describe the characteristics of encumbrances. We're going to learn what an encumbrance even means. And we're going to learn about encumbrances like liens, easements, and encroachments. And we're going to learn what those terms mean as well.
Encroachments.
So let's start off with the term estate. We've all heard that term estate. It's even in the words real estate, right? Well, what is an estate in land? Well, an estate in land describes the amount and kind of interest that a person has in real property. And there's two categories for estates in land. There are freehold estates or less than freehold, which are leasehold estates. Freehold is the category that describes ownership. And this chapter 6 is about the three types of freehold estates, which talk about the three forms of ownership, the three types of ownership estates in land. You're free to hold the property forever or a lifetime. It's the category of ownership. And the other category is a less than freehold estate, which is a leasehold, where you don't own it. And there are four types of leasehold estates, which we'll go over in chapter 12. Although I will name them in this chapter just so that you have a little introduction to them. But we actually go over them later on in chapter 12. Chapter 12 is all about leasing. Okay. So page 103. Let's highlight the amount and kind of, cross out the word ownership. They have the word ownership in this sentence because this particular chapter is talking about ownership category of estates and land. But just to have your straight up definition of what an estate and land is, cross out the word ownership. It is the amount and kind of interest that a person has in real property. It is an estate in land. And then on the next page, because they split this up to the next page, page 104, freehold estates is the ownership category. So right after that ownership category, three types. And actually above it, write the title that I have it here. There are two categories of estates in land. Two categories of estates in land. You're going to highlight freehold estates, and then you're going to write ownership category, and then in brackets, write three types. And then highlight leasehold estate, and then in brackets, write four types. And then write chapter 12, page 280, 220.
Oh, okay. Now I see where I'm at. Okay.
Okay.
You didn't bust up this stuff personally, right? No. You gave an estimate, said in your answer, Ms. Flores, that you calculated everything that I wrote, which was 2 TVs, $400. How'd you come up with that?
Is that from?
Let me know when you got all the notes.
Okay.
I'm done.
Give me a second.
Yep.
And three types.
Yeah, make sure you write above it on page 104, two categories of estates and land. And those categories are freehold estates, which is the ownership category, and there's three types that we're going to learn in the coming page. And then there's leasehold estates, which are less than freehold. You're not free to hold it forever or a lifetime. And there are four types of leasehold estates, and we're going to go over them in chapter 12 on page 228.
Mm-hmm.
Sorry, guys.
Got it?
Yeah.
Okay. So there are three types of freehold estates, and they are fee simple, fee determinable, and a life estate. So let's first write the number 3 before where it says freehold estates on page 104 here. Well, actually, you should first highlight it and then write number 3 so it doesn't smudge. Sorry. If you highlight things before you write them with ink, it won't smudge.
Mhm.
And then just highlight the 1, 2, 3. Fee simple, fee determinable, and life estate. So freehold estates are estates of an indeterminable length of time. A person may own that estate for a lifetime or forever. So 3 freehold estates are recognized in New Jersey are fee simple, fee determinable, and a life estate. The first 2 of these estates continue for an indefinite period of time, forever. You could even say who gets your property after you die. So they're inheritable by of the owner. Look at that. Okay, does it say that in the book actually? Is it cut off like that? By the of the owner?
By the heirs of the owner. The third estate ends on the death of.
Are inheritable by the heirs of the owner. Okay, I cut it off with my highlight there. Okay.
Mhm.
And the third estate ends on the death of the person of whose life the estate is based or measured against. So, before they get into the freehold estates, they do have a little blurb here about leasehold estates, and here's the screenshot from it. So this is what you're going to highlight there on 104. Leasehold estates involve tenants and are estates for a period of time. Leaseholds are considered to be personal property, not real property, because you don't own it. So therefore, it is an intangible asset, the lease. And I further clarify that with the statements above this in the slide. So leasehold estates involve tenants. A lease signifies the tenant's rights to occupy an owner's property for a limited period of time as defined in the lease. Leases involve tenants. The tenant is the lessee. Owners are known as the lessor because they're the one that gives the lease. They end in OR. The one that gets the lease ends in EE, right? And a lease is personal property. It's an intangible or incorporeal asset. It's not considered to be real property ownership. So a lease describes a tenant's right to occupy someone else's property for a limited period of time as defined in a lease, as well as the terms, the length of time, what exactly is being leased, and any other limitations on the estate. Like, you could rent a house from somebody and they could say, well, the garage is off limits. That's where I keep my car and my motorcycle, and I got my tools out there. So the garage is not for you. You could park in the driveway, but the garage ain't for you. Okay. Or you also have access to half of the basement, but not the whole basement because the landlord keeps their crap on the other side. You know, they have to specify what you don't have access to, because if they don't, you have access to the whole property that you're leasing. Now, there are 4 types of leasehold estates that we're going to discuss in chapter 12. So I'm just going to name you those 4 types of leasehold estates here. An estate for years, a periodic estate, an estate at will, and a tenancy at sufferance. Those are the 4 types of leasehold estates we're going to learn about. And just to give you a quick little rundown of what they are, you don't need to take notes on this right now. An estate for years, do not be fooled by the name. It does not need to be for a period of years. Its distinguishing characteristic is that it has a start date, it has an end date. you know when the lease term expires, when it ends. And then you either got to get out or you got to renew the lease. Okay, so an estate for years could be for 1 month, 3 months, 6 months, a year, 2 years, 3 years. The key thing is you know when it begins and you know when it ends. That's what an estate for years is. A periodic estate, also known as an estate from period to period, is a leasehold estate that automatically renews for the same amount of time that the original lease was written for. So it's a lease that does not expire. It does not have an expiration date, an end date in it. Instead, the date that is in it, it does have dates, but that is not an end date. It's a renewal date. So a periodic estate, it could be for a month, 3 months, 6 months, a year, 2 years. But the thing is, the dates that are in it is not an end date. It has a start date and a renewal date. And that unless you give the landlord your notice to quit, that you're not going to renew the lease, it's automatically going to renew for the same amount of time the original lease was for. So if the original lease was for 1 month, it's renewed again for another month. If it was for 3 months, it gets renewed for 3 more. If it was for a year, it gets renewed for another year. If it was for 3 years, it automatically renews for 3 more. Okay, that's how it works.
So that's mostly like on commercial buildings, right?
It could be on residential as well. A tenancy at will, at the landlord's will, but it could be at the tenant's as well. Either way, either party has to give 3 months notice to quit. So there is no end date stated. It's for an indefinite period of time. You're agreeing to rent from the landlord, but you got to get out when the landlord tells you to. They're going to give you 3 months notice in advance that you got to leave. And if you're going to terminate your lease, you need to let the landlord know, give me 3 months notice. Okay, because they're not telling you how long you could rent for. It's not a year or 6 months or anything. You're going to rent there until they tell you you got to go, but they'll give you 3 months notice. Okay, this is usually used when a property is being taken by eminent domain. You know, landlord don't know how long they're getting the property for, so they can't write you a year lease or 2-year lease or anything because they don't know when the state's going to take the property from them. So they sit, but they still got to pay their bills. They got to pay their taxes. They got to pay their mortgage. So they get a tenant in there to rent from them, and they say, "Listen, I could rent to you. I can't give you a lease for a certain period of time. The period is undefined. However, I will give you 3 months notice. When the state notifies me they're going to take the property, they're going to give me at least 3 months notice. So I will give you 3 months notice. And you got to get out within 3 months because I got to deliver the property vacant to the state."
Ooh.
And then we have a tenancy at sufferance. Suffering. Who's suffering? Tenancy at sufferance is when you have a tenant who wants, this is not squatters, this is somebody who had a valid lease. Their lease term had expired. They did not renew the lease. And they didn't move out. And most importantly, they're not paying rent. So you have, if you're a tenant at sufferance, you have the least rights of anybody to be to any real estate. You don't even have a lease to be there. You're not even paying rent. So a tenant at sufferance can be evicted at any time. And every day that they remain there, they cause the landlord to suffer. That's the tenancy at sufferance. That's where they get the name from. You don't have a valid lease. You did at one point in time. It expired. You didn't renew. You didn't move out, and you're not paying rent. So you're a holdover tenant who's not paying their rent. There's nothing wrong with a holdover tenant. If they are paying their rent, the landlord could accept their tenancy. But if they don't, you're causing the landlord to suffer. So you got to go. All right. See where we are time-wise. All right. Yes. Ooh. So let's go over those.
So basically, we if I want to give to somebody for the renting some one room or something, I'm the landlord?
If you're renting, if you own the real estate and you're renting to someone, you're the landlord. You're the lessor, the one that gave them the lease.
So you're the landlord to the two people, to the two rooms that you're renting out,
Correct.
but then you own the other part of the
And
house.
they're the lessee, they're the tenant. The lessee is the one that gets the lease.
Who gets the list? Okay.
The lessor is the one who gives the lease, and that's the owner of the property. You should
That's
not
the
be
lessor.
renting out property if you don't own it. Whose property are you renting out? Why are you collecting the rent? You know, you should not be renting out someone else's property. When you do, it's called subleasing.
Yeah,
And you,
that I was going to ask.
and you need the landlord's permission to do that. Most leases explicitly forbid you from doing this.
Mm-hmm. You're making money on top of them.
So I'm just saying with you, my son in this summer, he did subleasing in Boston. So that means landlord, then tenant, and then subleasing. Am I right?
Well, the landlord would have to give a tenant
And tenant to give to
Permission.
sublease.
to rent to someone else.
All right.
But if you are renting from a landlord and then you're renting to someone else, you're subleasing because the landlord is allowing you to.
Right.
And if that person that you're renting to does not pay the rent, you're still responsible to the landlord to pay it.
Okay.
Because
If the sublease doesn't pay.
you, not this other person. That's somebody you got a contract with. So that's your problem.
Okay. If
That's what you-
sublease guy person does not pay, I have to pay to landlord.
Yep, because the landlord rented to you,
Hmm. Okay.
not the other person. Right?
All right.
Oh,
Got
Well,
it. Got
to
it.
that in chapter 12. So
Mhm.
let's see. Do the highlights here and write these notes. These you see here with the different fonts, these looks like a handwriting font. Those are things that I wrote in there. Make sure that you write those things in as well. Do all these highlights and underlines and let me know when you got it.
Yes. Tick, 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 tick.
Then even if you see, you probably know, which is one of the nicer ones. And the mirror, you know, I'm like two colors, each of the mirrors, which there's no, there's people. Then I clearly think even $1,000 for the wall would be 3,300. We're doing too much. And all we have to do is lower that. And I don't believe.
So in that case, tenants get something, some kind of some discount or not when sublease is if tenant gets sublease,
No,
sublease pays
if you
to.
think they're paying more.
Oh, you're paying more.
Why would you rent a property to then rent it to someone else? You better be getting at least the same amount that you need to pay to the landlord because you got to pay the landlord.
I know.
So most likely you're doing it to make money being a landlord without owning real estate. Or you're doing it because you want to get out of your lease because you want to buy a house. So you get the landlord's permission to rent to someone else.
Mm.
But that's a little bit off topic right now. So let's just get these notes down right now. Let's go over stuff that's before us.
I got another highlighted color.
Okay, so as you guys are doing these highlights and taking these notes, I'll start reading from this slide instead of waiting.
Yeah.
the next slide. So fee simple estate is ownership forever without restrictions. Fee simple is the highest type of interest in real estate that's recognized by law. It goes by three names, actually. Fee simple estate, this highest form of ownership recognized by law, it's ownership forever without restrictions. It goes by three names: fee, fee simple, or fee simple absolute. So you're the owner of the property, you're entitled to all the rights of the property, your rights are not limited in any way. You own the land forever. So you could even dictate who gets it when you die. And how do you dictate who gets it when you die?
In the will.
In a will. There you go. Fee determinable estate is also ownership forever that is based on a restriction. Restrictions placed in deeds are called restrictive covenants. The word covenant means a legal promise. These are restrictive legal promises that you're agreeing to in the ownership. So it's ownership of real estate forever. However, your ownership is based on a restriction. So if an owner sells you their real estate, what are you getting? You're getting the real estate, the land, and any structures that are on it, and all the rights that are held by the seller. But what if the seller's rights were limited in some way? Well, you're only inheriting what they got. They can't create new rights for you that they didn't have. So for instance, if I own a piece of land and I bought it from somebody who kept the mineral rights to the oil in the ground, what do I own? I own the land, I own the real estate, and all the rights to the property except for the mineral rights. So when I sell the property to you, what do you get? You get the real estate plus the rights that I have. Are my rights lessened or restricted in some way? Yes. I don't have the rights to the minerals in the ground, to the oil. Somebody else, I bought it from somebody else with the agreement that they own the rights to the oil in the ground. So I can only sell you what I have, the real estate plus all of my rights. And my rights are all the rights in the real estate except for the mineral rights for the oil in the ground. I can only pass on to you ownership of what I own. Make sense?
Yes.
So there is a restriction in the deed that says I don't have the rights to the oil in the ground. Somebody else does. Now you could have restrictions that also dictate what you could do with the property. As long as those restrictions are not illegal restrictions, they're allowed. Like you can't have one that says you can't sell the property to a person who's of a certain religion or race or anything like that. That's discriminatory. You can't do that. So in New Jersey, fee determinable estate also goes by three names. It's also known as a conditional fee or a defeasible fee estate, because it is ownership based on a condition. And as long as you don't violate that condition, you remain the owner forever. Okay. So the ownership can be terminated on the occurrence or non-occurrence of a specified event. The ownership or the rights in the real estate. Like, for example, an uncle can give his property to his nephew with the agreement that he graduates from college. But until he graduates from college, there could be no alcoholic beverages on the property or consumed by anyone. Or he can lose that property, right? If he violates that restriction.
Mhm.
I say the nephew is a little wise guy. He's like, all right, sure, I'll take that ownership with that restriction. And then he goes and he sells the property, gets the money, and buys a different house where he could go then party on and drink away all day. Okay. Well, what about the house that he sold? The person who bought it, what did they get?
They
They
got the
the real
restriction.
estate and the rights that he held. And what were the rights that he held? They said that he can't have alcohol on the property or consumed by anyone until he graduates college. So the person who bought that property cannot have alcohol on that property or drink alcohol on that property until that kid who sold him the property graduates from college. And if he never graduates from college, you can never have alcohol on that property. That's just whack. Who would do that? You know?
Right.
But hey, if you agree to that term, you got to agree to it.
So when there's restrictions on it, they can't never go off unless that person takes them off that put them on there.
Or until the requirement to have the restriction removed has been met. He has to
So
graduate from college.
They can't go back and just change it.
Well, the person who put the restriction in the deed can, but not
Okay.
the person who sold you the property, because they are subject to the same restriction. They could only sell you the property with whatever rights that they have. They can't create new ones for you or remove restrictions that they had.
Okay.
You're going to remove it for themselves. How could they remove them for you? You know?
Mhm.
So that one's kind of a wacky example, but it could happen because there's nothing illegal about it.
Mm-hmm. Now they say like, okay, you're on this property, and I don't want y'all to mess up the foundation, so you can't put an indoor pool in. They could put restrictions like that, right?
You got zoning laws and building codes that'll deal with that.
Okay.
You know, I don't have any restrictions in the deed over something like that. That's something you got to deal with the city over. You know, if I sell you the property and you give me the money that I want for it, if you burn it to the ground afterwards. So usually it doesn't have to deal with improvements, but not always. You can get some people that they're emotionally attached to their home and they like the way that it is, and they don't want you maybe changing the architectural style or tearing down the house or putting additions on it. Can they put a restriction in the deed that says you can't put any additions on the house?
Yes.
Sure. Even though the city would allow you to put a restriction, the terms of the sale said that you could not. And if it turns out that later on you put an addition on the house and they find out about it, they could take you to court for violating the terms of your purchase, and you have to turn over the ownership to them.
Turn it back over, and you don't get no money back.
And they don't got to pay you anything for it because you violated the terms of the sale that you were perfectly aware of.
Mm-hmm.
So, yeah, I wouldn't do that. So this is what they call the possibility of revertal. The ownership can revert back to the previous owner or someone else who put the restriction in the deed. If you violate that term that you agreed to. Or they could write in the deed that if you violate that restriction, instead of the ownership coming back to me,
You'll
it
be
would
fine.
go with someone else. That someone else would be called a remainder man. So a remainder man is a third party named in the instrument. Instrument's just a fancy word for document. It's a third party named in an instrument to be a beneficiary in the event that you violate the terms of the sale. Instead of it going back to me, it would go to that other person.
Got it.
Okay, and then we have a life estate. A life estate is ownership. You notice I didn't say ownership forever.
Yeah.
It's ownership. A life estate is ownership of real estate, but it's based on the life. It's based on a life. I'm just going to start off by saying that because there's a couple different types of life estates. So we're just going to start off by saying that a life estate is ownership based on a life.
Okay.
So a life estate is limited to the life of a specific person. The owner of a normal life estate does not have the right to pass ownership to their heirs when they die, because the life estate that they have is based on their life. And when you die, the property goes back to the person who gave you or sold you the life estate.
Mm.
So therefore, you can't leave it in a will to someone. Because if I give you a life estate, I'm giving you ownership of my real estate for as long as you're alive.
Hmm.
Sure, you could have kids and raise your kids at that house and everything.
You just can't leave them in the house.
You can't leave them the house in your will though when you die, because you lose the ownership when you die. You don't
Mhm.
have ownership forever. That ownership is based on your life. And when you die, you lose the ownership. So your kids got to get out and find somewhere else to go, because
Oh,
the
wow.
ownership comes back to me, the person who gave you the life estate, or a remainder man, someone else that I named to get the property in the event when you eventually die, because we all die,
Mhm.
right?
You ever seen any of these life estate before?
Sure did. You did too. Very famous one. I'm going to give you an example on a coming slide.
I'm about to
Oh,
say, I think I know who you're talking about.
Okay, so let's see. So the owner of a normal life estate does not have the right to pass ownership to their heirs, because the life estate ends on the death of the owner. But just like the fee determinable estate that has a possibility of reverter, there is that same reversionary interest in a life estate. But it's not possible. It is going to happen at some point, because you are going to die at some point. So when is it that occurs? Now, can you sell a life estate? If I gave you my real estate, I gave you a life estate, I gave you my house for the
I
rest
can
of your
sell it.
life, can you sell it?
No,
Why not? You're the owner now.
because in there I have to give it back to you. Once I'm dead, I can't sell it.
No, don't rush it. Okay, I gave you the ownership of my house.
So
But
now I own it.
yeah, you own it. You're an owner.
Then I could do whatever I want.
Can you lease it out?
Yes.
Sure.
Yes.
Can you sell it? Sure.
Yes.
Sure you can. You're the owner. You can do whatever you
There's no
want.
restrictions on this one.
The only thing that the holder of a life estate cannot do is destroy its value.
Oh.
You have to pay the taxes on the property. You cannot risk losing that property. Because if you don't pay the taxes and you lose the property, that property gets lost. It gets sold at an auction. Someone else gets the ownership, right? So it doesn't go back to anybody. So you must maintain that property and pay the taxes on that property as well. Okay, you can't destroy the value of the property if you're the holder of a life estate. So-
Question.
Yeah.
Can I have a question?
Yes.
So, when the broker or the seller go to the agreement with the buyer, have to disclose what kind of title he's
property.
getting?
You always do. As a matter of fact, that buyer should be getting a title search done so that they know for themselves for sure, and they don't just trust you on that either. You know, that's what a title search is. They search the public records to see if there's any liens or restrictions on the property. And I would say a life estate is a restriction, right? Because if I gave my property to Tanshea and she sells it to you, what are you buying from her?
You buy a property, but the property has restriction.
You're buying the real estate and all the rights that she had to it. And what rights does she have to it? She has ownership, all the ownership rights to the property, but only as long as she's alive. So what are you buying? You're buying the real estate and all the rights that she has. Ownership based on her life.
So if she
So you got whatever you
she
pay,
died,
you price it accordingly. You know, how's her health? You may want to hire a bodyguard for her too to make sure she don't step out in front of a bus, because if she does and she gets hit by a bus and she gets killed, you lose the ownership of the property you bought from her that was based on her life.
Oh, that was a
So
good
that,
thing.
but,
You know what I'm saying?
so
Yep.
that was my, that's well the question. So who is going to disclose you what are you going to buy? Your lawyer?
She should. But either way, the attorneys will handle that, you know. But
Oh,
if
the
you're
attorney.
using an attorney, well, you better do your own due diligence. If you're not using an attorney, you should at least hire a title company to do a title search to make sure that you're getting everything that you're paying for. You know, if you're buying the ownership and you think that you're getting that ownership forever, free and clear, you think you're getting a fee simple estate, but in fact, you're getting a life estate. Is a life estate worth more than a fee simple estate?
Is it worth more?
Is a life estate worth more than a fee simple estate? Remember, a life estate is based on someone's life.
I don't think so.
Hell no is the answer. You should be like, hell no.
I was about to say no, because with life, you still have like restrictions and stuff.
Fee
Yes,
simple is ownership forever without restrictions. It's the highest type of interest recognized by law. It is ownership forever without any restriction.
Restrictions,
A
right.
life estate is ownership based
Right.
on someone's life.
Mhm.
So I would say that is a restriction, right? Because when
Yeah.
that person dies, you lose it.
Mhm. That's the only one without
So,
restrict-
do you price a life estate? I have no idea. I have no idea. This is why life estates are usually given and not sold. But can they be sold? Sure. How would you price it? I couldn't even tell you. I don't even have a clue. Okay. So let's talk about that. Let's do a little recap and then we'll talk about a famous example of a life estate. We'll talk about that tomorrow. Because we're at the end of the class already. Look at that. See, I got you all interested, and then I got
Yes, I was waiting.
So let's get this kicked off tomorrow morning. We'll do the recap here about the three types of freehold estates, and I'll give you the famous examples of life estate.